You're not going to believe what I uncovered. Specifically, the United States Court of Appeals for the Second Circuit really earned the title of inferior court, where their decision in the Antioch case dealing with those 4 sensitive places / licensing cases. Specifically, it turns out that the Second Circuit, in making this major decision on government-mandated gun-free zones, including that they are constitutional under the Second Amendment, relied upon a law that never existed. That's right. You're not going to believe what I uncovered when we get back. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a 2-time nominee for 2 different categories for the 2024 Gundy Awards, for the top male influencer in the Second Amendment space, as well as a top voice for the Second Amendment. I am honored to be nominated in both categories. All right, folks. So I had to double check this. I was pretty sure I was right, but I wanted to really double check this and run this to ground and give you all the information you needed. But as you know, in this Antioch case, which is really 4 cases put together, they were argued together in March, that the United States Court of Appeals for the Second Circuit out of New York City issued this 260-page decision with countless footnotes, all of which I've read. And I want to focus on, remember, there's 2 big things the case was dealing with. One was the licensing requirements for New York State. We'll do that in a separate video. And also, quote-unquote, sensitive places, which is a euphemism for government-mandated gun-free zones. We know that the Second Circuit did a good job in declaring that the default rule that says you can't go into any private property that's open for business to the public with a gun, even if you have a concealed carry permit, without first getting permission from the owner, that is unconstitutional under the Second Amendment. That is a good thing and a very important win, and that is a big deal that a 3-judge panel of really anti-gun judges, in my opinion, would knock that out. That is a major blow to the anti-gun movement, that even anti-gun judges are not willing to go along with that restrictive, that default provision theory, whatever you want to call that. But we're not going to talk about that right here, right now. We're going to talk about the other quote-unquote sensitive places that the Second Circuit panel upheld and said that banning guns in places like zoos, parks, theaters, conference centers, banquet halls, gatherings where people exercise constitutional rights, and so on. I want to deal with one specific topic here just to show you how wacky their decision is to uphold these laws. Now, there's a countless number of reasons why what they did here is wrong, but I want to focus on one particular, what I consider to be a headshot style argument, a winning argument, just to show you how terrible the reasoning was and sloppy the reasoning was by this 3-judge panel, because they actually relied upon as a major part of their decision to take away the rights of Americans in the state of New York to bring guns into places that they should be allowed to bring guns to protect themselves, their families, and their neighbors. The Second Circuit relied upon a law that never existed. That's right. And they didn't just cite it in like footnote 5050 as a passing reference that you sometimes see. No, this was the heart of the decision where they upheld these quote-unquote sensitive places laws. Specifically, for those of you following along the 261-page document, I will turn your attention to pages 181, really 183 through like 186, okay? On these pages here, they're doing an analysis of historical analogs. And just as a reminder, once the text is implicated, the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, obviously restricting the ability to carry guns in particular places, quote-unquote sensitive places, implicates the right to bear arms, meaning to bring your gun on those places. That shifts the burden. It shifts the burden, right, to the government to, guess what, to show their historical analogs at the time of the founding, that show that the people that adopted the Second Amendment understood there were certain restrictions on the Second Amendment, and this would be one of them. Of course, this court screwed up by looking to the post-Civil War era, but we're not going to focus on that for the purposes of this video. I just want to focus on their analysis at the time of the founding, because it just goes to show you how shoddy their legal reasoning and work was. Specifically, if you look at pages 181, here's what they say. They say that, according to the state of New York, the well-established tradition of regulating firearms in quintessential public forums, Here's the key language coming up. Such as fairs and markets. Fairs and markets. Fairs and markets is a critical phrase because it comes out of you'll see where. Justifies regulating firearms in public parks, which today often serve as public forums. As examples of this tradition, the state of New York reaches as far back as 1328. 1328. Remember, Columbus sails the ocean blue in 1492, so they're going back to a 1328 British statute that forbid going or riding armed by night or by day in fairs and markets, signed to the Statute of Northampton. Then they go on, and here's the key. They say the state of New York adduces evidence that at least 2 founding-era states, here's the key, 2 founding-era states and several Reconstruction-era states, which are totally irrelevant. We're only talking about the founding era. That's all that the Supreme Court's going to care about. That 2 founding-era states replicated this type of law. Well, what are those 2 states? Well, if you look at on page 184 of the decision, specifically page 184 and footnote 74, here's what the Second Circuit writes. Quote, sometimes in interpreting our own Constitution, it is better not to go too far back into antiquity. That is distinctly not the case, where evidence shows that medieval laws survived to become our founding fathers' laws. Okay? So what they're saying is, yeah, you can't rely on a 1328 Statute of Northampton from England unless that law was embraced by our founding fathers and was adopted here in America. Well, that's what they're saying. And they're saying that 2 states, this is what they allege, 2 states adopted the Statute of Northampton from the 1300s into America, Virginia and North Carolina. And this is very careful. Follow this carefully. You're going to really like where I'm going. Virginia and North Carolina were the 2 states in the United States that adopted at the time of the founding, according to the Second Circuit, the Statute of Northampton that supposedly said you can't bring guns into fairs and markets. Okay? Now, if you look at footnote 74, where they start breaking down Virginia and North Carolina's alleged adoption of the Statute of Northampton, here is what the Second Circuit says. 2 observations regarding these founding-era statutes are warranted. First, while the Virginia statute differed from the medieval English Northampton statute in that it prohibited conduct and not simply usage, i.e. bearing arms in terror of the county, the North Carolina statute, listen carefully, the North Carolina statute, like the Northampton statute, appears to have prohibited firearm carriage in general at fairs and markets regardless of conduct. So see what just happened here? That they point out that Virginia and North Carolina at the time of our founding, 1791, had both adopted a version of the Statute of Northampton from England that was adopted in England in the 1300s. But then they go on in footnote 74 and they narrow the scope of their authority even more by saying that, well, the Virginia statute wasn't just a restriction on carrying guns peaceably. It actually prevented you from carrying guns to the terror of the people. It's a terrorism statute. You can't shoot guns. You can't take your gun and you don't have a Second Amendment right to go into the middle of a square and start shooting your gun randomly. You're going to terrorize the people, and that's not considered peaceable carrying of guns for self-defense. Okay? So they basically say, yeah, we understand the Virginia law that adopted the Statute of Northampton deals with in terror of the people. And by the way, the U.S. Supreme Court agreed with this because the Supreme Court specifically declared that the Statute of Northampton and American analogs were not persuasive evidence that you cannot carry guns in America. They specifically rejected the Statute of Northampton as a precedent. Nevertheless, the Second Circuit is embracing the Statute of Northampton for the purposes of sensitive places analysis. But here is where the Second Circuit and the panel really earns the title of inferior judges or inferior courts. Article 3 of the U.S. Constitution refers to those courts below the U.S. Supreme Court as inferior courts. And here is how that panel on the Second Circuit has just earned the title of inferior court in yet a different definition. Because it turns out, where they write here in footnote 74, quote, the North Carolina statute, like the Northampton statute from England, appears to have prohibited firearm carriage in general at fairs and markets regardless of conduct. And it goes on to talk about how the North Carolina statute, i.e. the prohibition of carriage without any reference to conduct, blah, 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 justifies all of our restrictions that we're about to apply on modern day Americans, because at the time of the founding in North Carolina, there was restrictions on ability to carry guns in fairs and markets. And because in North Carolina had adopted the Statute of Northampton that prohibited the ability to carry guns in fairs and markets, anything that's analogous to a fair or a market where there's people crowding together, like zoos and parks and whatnot, here in America today, we can ban guns in the same way that North Carolina banned guns in fairs and markets at the time of the founding by adopting the Statute of Northampton. So that's the argument. So I have in my hand a document entitled A Collection of the Statutes of the Parliament of England in Force in the State of North Carolina. Something that was compiled by a man named Francois Xavier Martin, who was an attorney in 1792. And he did it for North Carolina. Well, here's the problem. And it should have been easy to understand if anyone paid attention to this as I see it. If you look at the relevant statute that the Second Circuit's relying on, it talks about, let me give you a couple phrases and tell me if this might have raised a red flag with you out there as Four Boxes Diner viewers who may not be on the federal bench. Some of the key language in this 1792 North Carolina statute, supposedly, ready? The king's servants, the ministers, the king's precepts, the king's justices, or other of the king's ministers, the king's justices, the king's ministers, the king's pleasure. Now, this was in 1792, 1 year after the Second Amendment was adopted. Many years after the Constitution was originally adopted, and many years beyond that since the American Revolution. So can we try to figure out why is a 1792 document talking about the king in America? The king in 1792? Could that have been a sign that maybe this authority, that the Second Circuit intellectual giants on the panel in New York City might be missing something? Well, yes, indeed, it turns out they were. Because several years ago in an article, which I'll put a link to down below, talking about fake history involving the right to bear arms, specifically dealing with a case out of the Ninth Circuit in 2021 called Young versus Hawaii. I'm sure many of you remember that case, dealing with open carry, I believe. Nevertheless, this is an article written by historian and friend of the Second Amendment, Stephen Halbrook. You're all familiar with him. He specifically pointed out that the Ninth Circuit relied on this exact same supposed North Carolina statute. And what did historian Stephen Halbrook have to say about this alleged statute that supposedly existed, that supposedly banned carriage in North Carolina in 1792 at the time of our founding, which the Second Circuit Court of Appeals just used to take away the right to carry guns in places like zoos and parks and other quote-unquote sensitive places in New York State in 2021? Well, here's what a historian Stephen Halbrook says about this law in the context of the Ninth Circuit's reliance upon it, and effectively this applies to the Second Circuit's reliance upon it today, because the history hasn't changed. Professor Halbrook, or Attorney Halbrook, says, quote, "The court's first example is the alleged North Carolina law of 1792 that repeated the statute in Northampton. The court should have thought something was fishy when it noted that the law did not even remove the references to the king. The fact is that the citation, 1792 NC Law 60, Chapter 3, is bogus. The actual source was a 1792 book by a lawyer who thought he was compiling the English statutes in force in North Carolina. Later compilers wrote that this work was utterly unworthy, as omitting many statutes always in force and inserting many others which were never and never could have been in force." Historian Stephen Halbrook had already run down this supposed North Carolina statute and pointed out that it was bogus, that it was never in force. And yet here we have the Second Circuit Court of Appeals relying upon a non-existent statute that was not in force as a major basis to show that the state of New York had demonstrated its burden and satisfied its burden of showing historical well-established traditions of restricting the ability of carrying guns peaceably in these places known as sensitive places, and it's simply not true. And again, I'll give you the quick rundown just generally why it's not true, and then I'll close. The bottom line is that the only thing that makes a sensitive place is if there's comprehensive security provided for by the government. If you look at the three sensitive places set forth by the Supreme Court in Bruen, those are polling places, those are legislative assemblies, and those are courthouses. Courthouses were protected by armed bailiffs. Legislative assembly or legislative chambers were protected by armed sergeant of arms or sergeant at arms. And polling places at the time of the founding were protected by armed sheriffs and their deputies. Comprehensive security, if the government does not provide comprehensive security like they do, for example, at TSA, it cannot be a sensitive place as a matter of historical tradition under American law. Beyond that, we know that if there's any historical ambiguity in the historical record as to whether or not a modern-day gun control law is upheld, the U.S. Supreme Court, in a footnote in the Bruen case, specifically said, to the extent there's any confusion about the historical record, we opt in favor of honoring the unqualified command of the Second Amendment's text, i.e., the right of the people to keep and bear arms shall not be infringed. That's not Mark Smith. That is the U.S. Supreme Court in the Bruen case. And last but not least, whenever you're talking about anything that speaks to the Statute of Northampton, and if you see the phrase markets or fairs, fairs and markets, that's exactly where the anti-gunners are going. They're going back to the 1300s. That's right, the 1300s. I believe that's several hundred years before the birth of William Shakespeare. I'm not even sure Chaucer had been born at that point, but you get the point. It's a long time ago, the 1300s. So if you hear fairs and markets and fairs in the context of a Second Amendment fight, that is definitely a reference to the Statute of Northampton out of England. The U.S. Supreme Court has already dealt with the Statute of Northampton in the Bruen case, and they specifically said that that was a law that prevented using guns or weapons to engage in terrorizing the people. It had absolutely nothing in terms of a restriction on the ability to carry one's firearm or one's arms to protect yourself and your family peaceably. It had nothing to do with restricting peaceable carrying. That's what the Bruen case said. That's what the Bruen case held. It only prevents you from engaging in acts of terror with the weapons. That's what the Statute of Northampton is about. And even to the extent there are states in the United States that adopted the Statute of Northampton, they only did so when it comes to the component of you cannot use the gun to terrorize people, which, again, you're not allowed to use guns to terrorize people now, but you're certainly allowed to use guns for peaceable, lawful affairs. Okay? Well, anyway, so again, it's crazy that the Second Circuit Court of Appeals made this terrible mistake, but ultimately I think this is good for the Second Amendment community because it really just goes to show you how bad this decision was reasoned, how lazy or sloppy, whatever you want to call it, in my opinion, this decision was. And I think when major mistakes like this get made and they get pointed out eventually to, let's say, the United States Supreme Court, it really does help hurt the credibility of these anti-gun rulings. So anyway, well, there you have it. I hope you learned something here today at the Four Boxes Diner. Don't forget to follow me at X at Four Boxes Diner. And if you feel free to share this video, we're trying to get our numbers up. I know we're sort of behind in all the subscriber counts compared to everyone else in the Second Amendment community, but we're working hard to catch up. So we'll see you again soon here at the Four Boxes Diner, and thanks for joining us.
Orders up. Table 2A.